Next page. Here's a structured summary of Chapter 7 based on your preferences: __. Chapter 7 Financial Regulation of Companies. 7.1 Introduction: The need for adequate financial regulation of companies. Companies may fail due to normal business risks, market changes, or technological shifts. For example, Kodak's decline due to digital advancements. Some failures result from dubious business practices or misleading financial reporting. The Companies Act, 2008, cannot prevent market-related risks but aims to prevent reckless or fraudulent trading, mandates companies to keep proper records, and prepare financial statements that fairly represent activities. 7.2 Factors affecting the documentation of a company's financial information. Companies must disclose reliable financial, societal, and environmental information to various stakeholders: shareholders, analysts, employees, trade unions, customers, suppliers. Some companies exceed statutory requirements, while others fall short. The Companies Act, 2008 prescribes mandatory records and financial disclosures. 7.3 The Companies Act, 2008 and Financial Information. 7.3.1 Company records, including accounting records. Companies must maintain accurate and complete records to ensure transparency and compliance. 7.3.2 Financial statements, including annual financial statements. Financial statements must give a true and fair view of the company's financial position. 7.4 Company records required in terms of Section 24. Companies must keep and store essential records as outlined in Section 24 of the Act. 7.5 Accounting records required in terms of regulations. Companies must maintain accounting records in accordance with regulatory requirements. 7.6 Registered office. Companies must have a registered office where records are kept and made available for inspection. 7.7 Access to company records. 7.7.1 Access by holders of securities. Shareholders and investors have the right to access certain company records. 7.7 To access by non-holders of securities. Limited access is granted to external parties based on statutory provisions. 7.8 Financial statements. 7.8.1 Personal liability for misleading financial statements. Individuals responsible for false or misleading financial statements may face personal liability. 7.8.2 Summaries of financial statements. Companies may provide summary financial statements in addition to full financial reports. 7.9 Annual financial statements. 7.9.1 Access to financial statements. Financial statements must be accessible to relevant stakeholders. 7.10 Financial reporting standards and the Financial Reporting Standards Council. Companies must adhere to prescribed financial reporting standards. The Financial Reporting Standards Council, FRSC, oversees financial reporting compliance. 7.11 Reporting requirements of different types of companies. Reporting obligations vary based on company size, nature, and structure. 7.12 Solvency and liquidity test and its effect on financial statements and records. Companies must conduct solvency and liquidity tests to determine financial health. 7.13 Annual returns and financial accountability supplements. Companies must submit annual returns and comply with financial accountability requirements. 7.14 Chapter 3 Requirements, Enhanced accountability and transparency. Companies must ensure transparency in financial and governance reporting. 7.15 Corporate governance, the King Code, and implications for accounting records and financial reporting. The King Code outlines best practices for corporate governance and financial reporting. 7.16 Stakeholder engagement and communication. Companies must engage with stakeholders and ensure open communication on financial matters. Examples of corporate collapses due to dubious business practices. 1. Fidentia Asset Management, 2007, a $689 million owed to widows and orphans misappropriated. Financial Services Board placed Fidentia under curatorship. Former CEO accused of falsifying assets, backdating documents, and misleading reports. 2. Masterbond Group, 1991, raised $300 million from investors despite financial distress. 22,000 investors lost $600 million. Auditors paid $33 million for issuing false and misleading financial statements. 3. Steinhoff International, 2017, expanded aggressively through acquisitions, but engaged in fraudulent financial reporting. Early warning signs, 2007, lack of transparency in financial disclosures. Deloitte, 2017, refused to express an opinion on financial statements. Viceroy Research Report, 2017, revealed related party transactions inflating earnings. Share price fell over 90%, leading to massive investor losses. This summary maintains depth while streamlining content for efficiency. Let me know if you need refinements. Next page. Table 7.1 Transparency, Accountability, and Integrity of Companies. Section heading discussed in Chapter 7. Section 23 External Companies and Registered Office 7.6, also in Chapter 2, 2.6 and the 2nd of September 2014 Section 24 Form and Standards for Company Records 7.3.1, 7.4, 7.5. Section 25 Location of Company Records 7.6. Section 26 Access to Company Records 7.7. Section 27 Financial Year of Company 7.9. Section 28 Accounting Records 7.4, 7.5. Section 29 Financial Statements 7.3, 2, 7.8. Section 30 Annual Financial Statements 7.9. Section 31 Access to Financial Statements or Related Information 7.9.1. Section 32 Use of Company Name and Registration Number Chapter 2, 2.11 Section 33 Annual Return 7.13. Section 34 Additional Accountability Requirements for Certain Companies 7.14. This table maps statutory sections to relevant discussions in the chapter for easy reference. Let me know if you need any refinements. Next page. Study Notes, Transparency, Accountability, and Integrity of Companies. 7.2 Factors affecting the documentation of a company's financial information. Several factors influence the nature, content, and timing of financial information release, including Companies Act, 2008, governs financial documentation requirements. JSE listing requirements, applies to listed companies. Prescribed Financial Reporting Standards, sets minimum financial reporting standards. Good Business Practice, King IV Code, encourages transparency and ethical governance. Stakeholder Information Needs, influences the level of disclosure. Good Business Practice example, Grindrod Limited. Publishes financial reports beyond legal requirements, demonstrating transparency and accountability. Additional reports include Audit and Risk Committee Report, Value Added Statement, Share Performance Statement, Corporate Governance Report, Social Performance Report, Corporate Social Investment Statement, Environmental Performance Report. 7.3 The Companies Act, 2008 and Financial Information. The Act requires companies to 1. Keep certain company records, including accounting records. 2. Prepare annual financial statements. 7.3.1 Company records, including accounting records, company records versus accounting records. Accounting records are a subset of company records. Key sections of the Companies Act, 2008 on company records. Section 1 defines records as per Section 24(1). Section 24 specifies the form and standards for company records, including Memorandum of Incorporation, MOI, Securities Register. Accounting records. Section 28 requires companies to maintain accounting records in compliance with financial reporting obligations, defined as records, written or electronic, concerning financial affairs including purchase and sales records, general and subsidiary ledgers, other financial documents and books. Minister of Trade and Industry may publish regulations on accounting records. Section 25 specifies that company records must be accessible at the registered office. Companies must notify the Companies and Intellectual Property Commission, CIPC, if records are stored elsewhere. Section 26 provides rights of access to company records. 7.3 to financial statements including annual financial statements. Definition of financial statements. Section 1, broad definition covering more than just annual statements. Key sections of the Companies Act, 2008 on financial statements. Section 29 sets financial statement standards. Must fairly present the company's affairs. Minimum content requirements must be met. Section 30 governs annual financial statements. Section 31 grants access rights to financial statements. Factors determining financial statement requirements. Type of company, public versus private. Purpose, for profit versus non-profit. Business activities, for example fiduciary asset management. Public versus private company compliance. Public companies must comply with International Financial Reporting Standards, IFRS. Most private companies exempt from full IFRS compliance. Section 29 compliance. Financial statements must fairly present the company's state of affairs, explain financial transactions and position, include assets, liabilities, equity, income, expenses, and other prescribed information. Accounting records must be adequate to ensure fair financial statement presentation. These notes summarize the transparency and accountability requirements for companies as outlined in Chapter 7 of the Companies Act, 2008. Let me know if you need further refinement. Next page. Study notes. Company records required in terms of Section 24. 7.4 Company records required by Section 24. All companies must maintain the following records under Section 24 of the Companies Act, 2008. Memorandum of Incorporation, MOI, and any amendments. Rules made by directors. Record of directors. Reports presented at annual general meetings, AGMs. Annual financial statements. Accounting records as required by the Act. Notices and minutes of shareholders' meetings. Shareholders' resolutions and related documents. Written communications sent to any class of shareholders. Minutes of directors and directors' committee meetings, including audit committee meetings. Securities register for profit companies. Company records and accounting records. Company records contain essential details about a company's operations and governance, including company type, profit or non-profit, private or public, company control, record of directors, securities holders, securities register, communication with shareholders, shareholder resolutions and related documents, meeting records, minutes of directors and shareholders' meetings, accounting records as part of company records. Significance, essential for tracking business performance and ensuring compliance. Benefits of accurate accounting records. Timely and accurate financial statement preparation. Data-driven business decision-making. Real-time financial status assessment. Performance evaluation against business projections. Keeping detailed and up-to-date company and accounting records is crucial for legal compliance, financial transparency, and business success. Next page. Study notes. Company records to be maintained in terms of Section 24. Table 7.2, Company records and retention periods. Type of company record. Companies Act reference retention period. Copy of the MOI and any amendments or alterations. Section 24(3) and indefinitely. Rules made by directors under Section 15(3), 5 Section 24(3) and indefinitely. Record of directors, including current and former directors' details, Section 24(3), 7 years after the person ceases to be a director. Copies of all reports presented at AGM Section 24(3)(c) 7 years after the meeting date. Copies of all annual financial statements Section 24(3)(c) 2, 7 years after issuance. Accounting records required under the Act Section 24(3)(c) 3, current financial year plus previous 7 financial years. Notices and minutes of shareholders' meetings and resolutions adopted Section 24(3)(d) 7 years after adoption. Documents provided to shareholders regarding resolutions Section 24(3)(d) 2, 7 years after adoption. Copies of written communications sent to all holders of a class of securities Section 24(3), 7 years after issuance. Minutes of directors' meetings, directors' committees, and audit committee meetings Section 24(3) F 7 years. Securities Register for for-profit companies, Section 24(4), Section 50 indefinitely. Records under Section 85, Public Company Transparency and Accountability Requirements, including Company Secretary and Auditor details, Section 24(4), Section 85 indefinitely. Key points on Securities Register. All for-profit companies must maintain a securities register under Section 50. Securities include shares, debentures, and other financial instruments issued by the company. Enhanced record-keeping obligations under Section 85 apply to public companies and require maintaining records of the company's secretary and auditor. These record-keeping requirements ensure transparency, accountability and compliance with financial and governance regulations under the Companies Act, 2008. Next page. Study Notes, Directors' Records as per Section 24(5) of the Companies Act, 2008. Mandatory Director Information, Section 24(5). Each company must maintain a record of directors containing the following details for each director: full name and any former names, identity number or date of birth if no identity number exists, nationality and passport number if not a South African citizen, occupation, date of most recent election or appointment as director, name and registration number of every other company or foreign company where the person is a director, nationality of a foreign company where the director holds a position, any other prescribed information. Additional requirements under regulations. In addition to Section 24(5), regulations require companies to record address for service, i.e. official address for legal notices, professional qualifications and experience for companies required to have an audit committee, required to comply with Section 94(5) and Regulation 42 regarding audit committee members' expertise. These record-keeping requirements ensure transparency and compliance with corporate governance standards under the Companies Act, 2008. Next page. Study Notes, Company Records and Access, Companies Act, 2008 7.5 Accounting records required in terms of regulations. Companies must keep accounting records necessary to meet reporting obligations under the Companies Act, 2008. Requirements in the Companies Act are in addition to those in other laws, for example, Income Tax Act, which mandates keeping books of prime entry for 5 years. Types of accounting records required. Asset Register, Liabilities and Obligations Register, Record of loans to directors, officers, shareholders, employees, related persons, record of property held in a fiduciary capacity, per Consumer Protection Act, S65(2), Register of Revenues and Expenditures. Daily records, cash flow, credit purchases and sales, statements for all bank accounts with vouchers, Register of loans received from shareholders, directors, officers, employees, related persons, Register of guarantees issued for third-party obligations, Register of future contractual obligations. Storage requirements. Kept at or accessible from the company's registered office. Precautions against loss, theft, falsification, damage, or destruction must be in place. Records must be retrievable in readable and printable form. The Companies and Intellectual Property Commission, CIPC, may issue compliance notices for non-compliance. _ 7.6 Registered Office. Every company must have a registered office in South Africa. Records required by Section 24 must be kept at this office or another notified location. Accounting records under Section 28(2) must also be accessible from the registered office. The notice of incorporation must include details of the registered office, and any changes must be filed with the SIP. Records must be in written, electronic, or convertible form. Case law definition of registered office. Sibakulu Construction, Proprietary, Limited v. Wedgwood Village Golf and Country Estate, Proprietary, Limited. The court ruled that a company can only reside at one place, which must be its registered office or, if it has multiple offices, its principal office. Companies Act, 2008 differs from Companies Act, 1973, which allowed separation of a company's main place of business from its registered office. Registered office equals principal place of business for jurisdictional purposes. _ 7.7 Access to company records. 7.7.1 Access by holders of securities. Section 26 grants rights to shareholders and members of non-profits to inspect and copy and rules. Records of directors. Reports to annual meetings and annual financial statements. Notices, minutes and communications. Securities register for profit companies. 7.7 Do access by non-security holders. Any person may inspect documents filed with the SIP, for example, MWA. Section 26(2) Rights. Inspect securities register, profit companies. Inspect register of directors, all companies. Case law access to securities register. Basson v. On Point Engineers, Proprietary, Limited. Media sought access to securities registers to investigate state tender beneficiaries. Court ruled access must be granted, and no reasons are required to inspect. Section 26(9) Failure to grant access is an offense. Nova Property Group Holdings Limited v. Cobbett. Company denied access to securities register, arguing privacy violations. Court ruled right to access is unqualified under S26(2). Companies operate in public interest. Right of access outweighs privacy concerns. Shareholder privacy rights minimally affected since access is limited to securities and directors' registers. Company was ordered to grant access. These provisions ensure transparency, accountability, and public access to key company records under the Companies Act, 2008. Next page. 7.8 Financial Statements. Definition: Companies Act, 2008. A financial statement includes annual financial statements and provisional annual financial statements, interim or preliminary reports, group and consolidated financial statements for groups of companies, financial information in a circular, prospectus, or provisional announcement of results relied upon by creditors, security holders, or regulators. The definition is broad and ensures that all financial statements satisfy prescribed financial reporting standards, fairly present the state of the company's business and financial position, show assets, liabilities, equity, income, and expenses, indicate publication date and accounting period. Additionally, S29(2) mandates that financial statements must not be false, misleading, or incomplete in any material respect. Difference between financial statements and annual financial statements. Financial statements, a broad term covering reports, circulars, prospectuses, and announcements. Annual financial statements, a subset of financial statements, focusing on yearly performance. The Act enforces common financial reporting standards to enhance transparency, comparability, and consistency across companies. Dubious accounting practices and Enron scandal. Enron Corporation used misleading accounting techniques, overstating profits and concealing liabilities. led to bankruptcy, 2001, and the dissolution of Arthur Andersen, a major auditing firm, resulted in Sarbanes-Oxley Act, 2002, in the U.S., increasing financial transparency and corporate governance. South Africa responded by incorporating IFRS, International Financial Reporting Standards, into the Companies Act, 2008. 7.8.1 Personal liability for misleading financial statements. S77(3)(b). Directors are liable for losses if they allow business operations despite knowing they violate S22(1). Prohibition of reckless and fraudulent trading. S77(3)(d). Directors are liable for company losses if they sign, consent to, or authorize false or misleading financial statements. S218(2). Anyone contravening the Act is liable for damages suffered by any other person. Case law, First Rand Bank v. Fourie. Defendant provided misleading financial statements to the plaintiff bank. The bank lent funds based on those statements. Court held this amounted to reckless and fraudulent trading and held the defendant personally liable under S424 of the Companies Act, 1973. 7.8. 2 Summaries of financial statements. Companies may provide summarized financial statements. Requirements for summaries. Must comply with prescribed regulations. First page must state it is a summary. Must indicate steps to obtain the full financial statement. Minister may regulate form and content requirements. Next page. Study notes, annual financial statements and financial reporting standards. 7.9 Annual financial statements. Requirement, Companies Act, 2008. All companies must prepare annual financial statements, AFS, within 6 months after the financial year end. This requirement is unalterable in a company's Memorandum of Incorporation, MOI. Companies must have a fixed financial year, subject to modifications under S27. Content requirements, S30, Companies Act, 2008. Auditors report, if audited. Directors report on the company's affairs, business and financial status. Approval and signature by the board and an authorized director. Presentation to the first shareholders meeting post-approval. Fair presentation of financial position, transactions and business operations. Mandatory disclosures in AFS. Date of production and accounting period. Assets, liabilities and equity balance sheet. Income and expenses, income statement. Any other prescribed information, S34. Compliance with financial reporting standards. Statement on audit status, audited, independently reviewed, or unaudited. 7.9.1 Access to financial statements, S31 Companies Act, 2008, shareholders. Without demand, right to notice of publication of AFS. On demand, right to a free copy of AFS. Judgment creditors. Right to demand a free copy if disposable assets appear insufficient to satisfy a judgment. Trade unions. Right to access company financial statements for business rescue purposes. 7.10 Financial Reporting Standards and the Financial Reporting Standards Council, FRSC, Regulation, S29(4) and 5, Companies Act, 2008. Financial reporting standards apply based on company type. FRSC advises the Minister on financial reporting matters and regulations. Standards must align with International Financial Reporting Standards, IFRS. IFRS and compliance. IFRS applies to all Johannesburg Stock Exchange, JSE, listed companies since 2005. Companies must comply with either full IFRS for large companies, IFRS for SMEs, for smaller companies. Ensures international consistency in financial reporting, benefiting foreign investors. No deviation from prescribed accounting standards. Companies Act, 1973 allowed deviation from GAAP standards if reasons were disclosed. Companies Act, 2008 prohibits such deviations. Prevents manipulation of financial reports to misrepresent financial health. GAAP for SMEs, 2007. Before FRSC, GAAP for SMEs was approved by APB, allows SMEs with no public accountability to use less stringent standards. Financial statements must explicitly state compliance with GAAP for SMEs. Next page. Study notes, annual financial statements and reporting requirements. 7.9 Annual financial statements. Requirement. All companies must produce annual financial statements within 6 months of the financial year end, unalterable provision in WA. Companies must have a fixed financial year, modifiable under S27. Content requirements, S30. Auditor's report, if audited. Director's report on state of affairs, business and profit or loss. Board approval and signature by an authorized director. Presentation to first shareholders meeting after board approval. Financial statements must state date of production and accounting period. Show assets, liabilities, equity, balance sheet and statement of changes in equity. Show income and expenses, income statement. Include prescribed information, S34. Satisfy financial reporting standards. Indicate audit status on the first page. If audited, include the auditor's report. Table 7.3, Required disclosures in audited statements. Director and prescribed officeholder remuneration, S34A, 6. Fees, salary, bonuses, expense allowances, pension contributions. Share options, financial assistance, S44, loans, S45. Pensions and compensation, S34B, C. Securities issued to directors or related persons, S34D. Director service contracts, S34E. 7.9.1 Access to financial statements, S31 Shareholders. Right to notice of publication of annual financial statements. Right to one free copy on demand. Judgment creditors. If the company lacks sufficient assets, creditors can demand a free copy of the latest financial statements. Trade unions. Access for business rescue purposes. 7.10 Financial Reporting Standards and FRSC. Financial Reporting Standards, S29-4, 5. Prescribed standards must align with IFRS, International Financial Reporting Standards. Different categories of companies have varying standards. Financial Reporting Standards Council, FRSC. Established under Chapter 8D of the Act. Advises Minister on Financial Reporting Regulations. Replace the Accounting Practices Board, APB. IFRS compliance. Mandatory for JSE-listed companies since 2005. Companies must follow IFRS or IFRS for SMEs depending on category. No deviation from standards allowed, unlike Companies Act 1973. GAAP for SMEs, 2007. Allows less stringent standards for private companies with no public accountability. 7.11 Reporting requirements by company type. Table 7.5, Financial reporting standards for different companies. Profit companies. State-owned, IFRS, overridden by Public Finance Management Act, PFMA, 2003 if conflicts arise. Public, listed, IFRS. Exchange listing rules prevail if aligned with IFRS. Public, unlisted, IFRS or IFRS for SMEs if eligible. Private, public interest score greater than or equal to 350, IFRS or IFRS for SMEs. Private, public interest score 100 to 350, or less than 100 but independently compiled, IFRS. IFRS for SMEs, or SA GAAP. Private, less than 100, internally compiled, no prescribed standard. Non-profit companies. Audit required, Reg 28-2B, IFRS, subject to PFMA. Public interest score greater than or equal to 350, IFRS or IFRS for SMEs. Public interest for 100 to 350, or less than 100 but independently compiled, IFRS. IFRS for SMEs, or SA GAAP. Public interest score less than 100 internally compiled, no prescribed standard. Independently compiled statements. Prepared by independent accounting professional, based on company's financial records, must comply with relevant financial reporting standards. Next page. Study notes, solvency and liquidity test, annual returns and corporate governance. 7.12 Solvency and liquidity test and its effect on financial statements. Capital maintenance shift. The Companies Act 2008 replaces the par value capital maintenance regime with the solvency and liquidity test. This shift affects financial disclosures and accounting records. Solvency and liquidity test, S4. A company meets the test if assets, fairly valued, greater than or equal to liabilities, fairly valued. Fair valuation includes contingent assets and liabilities. Consideration must be based on accounting records, S28, accurate, complete, and sufficient for financial statement preparation. Financial statements, S29, fairly presented and IFRS compliant. Impact on accounting methods. Historic cost accounting may no longer suffice. Fair valuation and market values become central. Companies must consider all foreseeable financial circumstances. Test application scenarios. Financial assistance for security subscriptions, S44. Loans or financial assistance to directors, S45. Distributions, S46. Cash payments in lieu of capitalization shares, S47. Share buybacks, S48. 7.13 Annual returns and financial accountability supplements. Filing obligation, S33. All companies, including external companies operating in SA, must file an annual return. If audited, they must submit their annual financial statements. If not audited, they must file a financial accountability supplement. Voluntarily audited companies can submit financial statements or financial accountability supplement. Case law, failure to file annual return and deregistration. Absa Bank Limited VSIP and Voidro Investment 19cc. Deregistration, S823A, occurs when a company fails to file returns for 2+ years and does not provide satisfactory reasons. Legal effect. Deregistration not equal to dissolution or winding up. The company loses legal personality, but still exists as an association. Members become personally liable for debts incurred post-deregistration. Court relied on ex parte Jacobson, in re Alec Jacobson Holdings, Proprietary, Limited, confirming deregistration effects. 7.14 Chapter 3 Requirements, Enhanced Accountability and Transparency. Applicable to public companies, state-owned companies unless exempted, mandatory appointments. Company Secretary, SS 86 to 89, Auditor, SS 90 to 93, Audit Committee, S 94, Company Records, Secretaries and Auditors. Name, former names, date of appointment, registration details for firms, individual responsible for audits, S 93, changes and dates of changes. 7.15 Corporate Governance, King Code, and Financial Reporting. King Code Evolution. King I, 1994, King II, King III, King IV, 2016, effective April 2017. King IV applies an apply and explain approach, versus King III's apply or explain. Key corporate governance principles, King IV. 1. Ethical leadership and corporate governance. 2. Boards and directors, including remuneration policies. 3. Audit committees. 4. Risk governance. 5. IT governance. 6. Compliance with laws and standards. 7. Internal audit. 8. Stakeholder relationship governance. 9. Integrated reporting and disclosure. Key changes in King 4. Reduced principles, from 75 in King 3 to 17 in King 4. Focus on outcomes, not just compliance. Integrated reporting aligned with IRC 2013. Sector supplements for industry-specific governance. Financial reporting implications. Going concern assessment is crucial. Risk management prioritized. Risks should be identified, evaluated and managed, not necessarily avoided. Triple bottom line approach. Financial, social and environmental reporting. People, planet, profit over just profit reporting. Next page. Study notes, stakeholder engagement and communication. 7.16 Stakeholder engagement and financial information needs. Impact on financial statements. Companies must identify stakeholders and their information needs. The nature, size and shareholding diversity influence reporting requirements. Financial statements should include relevant information for key users. Stakeholders and their information needs. Table 7.6 Stakeholder key information needs. Investors' actual and potential, future dividend certainty and amounts. Risk of capital loss. Capital growth potential. Timing for investment or selling shares. Employees including trade unions, directors, managers, other employees, risk of liquidation. Company's cash flow generation. Ability to pay salaries, benefits, pensions and bonuses. Share option benefits. Lenders, long-term and short-term, secured and unsecured creditors, certainty of capital repayment. Interest payment certainty. Risk of lending more. Need for security. Suppliers and traders, cash and credit suppliers, cash flow generation capability. Certainty of payments. Risk of further supply. Trade discounts based on volumes. Customers, risk of discontinued supply. Risk of company liquidation. Government and regulators, SARS, DTI, local authorities, Competition Board, regulation of company activities. Need for state assistance. Tax liabilities. Trade policies and incentives. Public, environmental concerns. Economic contributions. Analysts, stockbrokers and agents, company performance and growth potential. Conclusion: companies should align financial reporting with stakeholder expectations to enhance transparency and decision-making. Next page. Study notes, Chapter 8, Securities and Share Transfers. 8.1 Introduction and Definitions. Securities Register. Profit companies must maintain a securities register listing current holders of securities, defined in S1 of the Companies Act, 2008 as including shares, debentures, and other instruments issued by a profit company. Covers both equity and debt instruments. Other relevant chapters. Chapter 4, Authorized, Issued and Unissued Shares. Chapter 5, Definitions of Securities, Financial Instruments, Shares and Debentures, Shareholder Powers, Meetings, Shareholder Rights, including Majority Rule and Minority Protections. Shares as personal rights. Shares are a bundle of personal rights entitling holders to company interests. Efficiency in trading listed securities. Listed versus unlisted securities. Listed securities are traded on an exchange, for example, JSE. Transition to electronic trading. Previously, shares were traded physically at the JSE. Electronic trading system introduced for efficiency and accuracy. Ensures quick ownership changes, transparency, and reduced settlement risk. Improved global perception and competitiveness of South Africa's market. Purpose of Chapter 8. Differences between paper-based, certificated, and paperless, uncertificated, securities. Need for a securities register for transparency. Transfer procedures for certificated and uncertificated securities. 8.2 Certificated and uncertificated securities. Certificated securities. Evidenced by a physical certificate. Uncertificated securities. Not evidenced by a physical certificate. Held in collective custody by a central securities depository, CSD. Transferred electronically without a written instrument. Key provisions in Companies Act, 2008. Securities must be either certificated or uncertificated. Only uncertificated securities can be traded on the JSE. Rights of security holders remain the same regardless of security type. S54 allows conversion between certificated and uncertificated securities. S49(5) read with S54, certificated securities can become uncertificated. Case study, Flecky, Proprietary, Limited v. FNB Securities, Proprietary, Limited. Court ruling. S54 is clear, holders can convert uncertificated securities into certificated ones at their discretion. Reason for electronic trading adoption. Certificated securities required excessive paperwork, making JSE trading inefficient. 1998 Amendment to the Companies Act, 1973 introduced electronic securities. By 2002, all JSE-listed equities were traded electronically. Companies Act, 2008 formalized uncertificated securities. 8. 2.1 Nature of a certificate. A share certificate. Not a negotiable instrument, i.e., it has no inherent value. Serves as proof of ownership, but is not required for ownership transfer. A new certificate is issued when ownership changes. Can be challenged by a beneficial owner if the registered holder is merely a nominee. 8. 2. Certificate requirements. A certificate must state company name, holder's name, number and class of securities, any transfer restrictions, for example, preemption rights in WAR, signed by 2 authorized board members. 8. 2.3 Securities register. Companies must maintain a securities register in prescribed form. Register includes names and addresses of certificated security holders, number of securities issued to each holder, total uncertificated securities held, legal status. Securities register serves as proof unless evidence suggests otherwise. Uncertificated securities register. If a company issues uncertificated securities or converts certificated securities, the register must be maintained by a participant or CSD. This register forms part of the securities register. Next page. Chapter 8, Securities and Share Transfers. 8.1 Introduction and Definitions. A profit company must maintain a securities register, listing current holders of shares and other securities. Definition of securities. Companies Act 2008, S1, includes shares, debentures, and other instruments issued by a profit company. Shares versus securities. Shares represent ownership in a company. Securities include both shares and debt instruments like debentures. Shares are classified as personal rights or a bundle of rights granting an interest in the company. Need for efficient trading of listed securities. Listed securities, for example, on the JSE, must be efficiently traded. Transition from physical trading floors to an electronic trading system enabled market growth. Electronic trading benefits. Faster transactions and settlement. Improved market transparency and efficiency. Lower operational risks and costs. Increased international competitiveness. The Companies Act 2008 provides distinct transfer procedures for certificated and uncertificated securities. 8.2 Certificated and uncertificated securities. Certificated securities, ownership evidenced by a physical document. Uncertificated securities. No physical document, ownership is recorded electronically. Held in collective custody by a central securities depository, CSD. Transfer occurs electronically without written instruments. Trading on the JSE, only uncertificated securities are permitted. Conversion between types. S54 of the Companies Act 2008 allows holders to convert uncertificated securities into certificated form. S49(5) and S54. Certificated securities can become uncertificated. Case law, Flecky, Proprietary, Limited v. FNB Securities, Proprietary, Limited. Court's ruling on S54. Holders of uncertificated securities have the right to request a physical certificate. The shift from paper-based to electronic trading was necessary for efficiency. By 2002, all JSE-listed equities were electronically traded and settled. _8. 2.1 Nature of a certificate. Not a negotiable instrument, it only evidences ownership. If ownership transfers, a new certificate is issued. Presumptive proof, ownership is presumed unless proven otherwise. _8. 2 Certificate requirements. A share certificate must state company name, holder's name, number and class of securities, any transfer restrictions, for example, imposed preemptive rights. Signature requirement, 2 board-authorized signatories must sign. _8. 3 Securities register. Every company must maintain a securities register detailing issued securities. Required entries. Certificated securities, names, addresses, and number of securities per holder. Uncertificated securities, total number recorded. The register is prima facie evidence of recorded facts unless proven otherwise. Uncertificated securities register, managed by a CSD participant and forms part of the company's securities register. _8.3 Central Securities Depository and Participants. A CSD holds uncertificated securities and enables electronic transfers. Before CSDs, paper certificates were exchanged after transactions. In South Africa, the licensed CSD is Strata Limited. Only participants, financial institutions like banks, can liaise with Strata. Strata and dematerialization. Dematerialization, replacing paper certificates with electronic ownership records. Trading process. 1. Broker enters an order on the JSE. 2. Once matched, the broker submits details to a CSD participant. 3. The CSD participant confirms the buyer has funds. 4. Strata transfers securities from seller to buyer electronically. Licensed CSD participants. Major participants include Absa Bank Limited, First Rand Bank Limited, Standard Bank of South Africa Limited, South African Reserve Bank, Société Générale Johannesburg Branch. Access to uncertificated securities register can only be inspected through the company and as per CSD rules. _8.4 Securities held by nominees. Nominee: a person or company approved to hold securities on behalf of another. The nominee is the registered holder but not the beneficial owner. Beneficial owner: the actual owner entitled to dividends, voting rights and sale proceeds. Legal principles governing nominee holdings. Nominee as an agent must act per the beneficial owner's instructions. Vindicatory right: if a nominee unlawfully sells securities, the beneficial owner can claim them back. The buyer, who acted in good faith, may only sue the nominee for damages. Companies Act 2008, S56. S56(1). Securities may be held by a nominee unless the MOA states otherwise. S56(3) and 4. A nominee holding shares in a public company must disclose the identity of the beneficial owners, the number and class of securities held. Updates must be provided monthly. Regulated companies and disclosure. Public and certain private companies must maintain a register of nominee disclosures. If audited, S32, they must publish beneficial owners holding greater than or equal to 5% of a class of securities. Concerns with nominee holdings. Insider trading, harder to detect. Minority shareholder protection, identifying controlling shareholders is difficult. Hostile takeovers, incumbent directors may not receive prior warning. Competition law enforcement, identifying share ownership is complex. Communication barriers, companies interact only with registered nominee holders. Voting rights of beneficial owners, S56(9). A beneficial owner may vote only if their interest includes voting rights. Their name appears on the company's register of disclosures. They hold a proxy from the registered nominee. Issues with S56(2). Extended meaning of beneficial interest includes a holding company if its subsidiary holds a beneficial interest. Problem: a subsidiary and its holding company cannot both have the same beneficial interest. Practical difficulty: who should the nominee report as the beneficial owner, the subsidiary or the holding company? Company's right to demand disclosure. If a company suspects nominee holdings, it may require the nominee to disclose beneficial owners, the beneficial owner to confirm ownership extent. This summary provides a structured and detailed overview of Chapter 8, focusing on key legal principles, legislation, and case law related to securities, nominee holdings, and share transfers under the Companies Act 2008. Let me know if you need further refinements or additional case law references. Next. Page 8.3 Central Securities Depository and Participants. A Central Securities Depository, CSD, holds securities in an uncertificated, dematerialized form, allowing ownership transfers electronically instead of using physical certificates. In South Africa, the licensed CSD is Strata Limited, Strata, which operates the electronic system for holding and transferring uncertificated securities. Participants are entities authorized to interact directly with Strata. Most participants are banks. Strata and dematerialization. Dematerialization, process of replacing paper share certificates with electronic ownership records. Strata acts as the back office for transactions occurring on the JSE, ensuring buyers and sellers are correctly recorded and paid. Brokers execute orders, which are submitted to a CSD participant, who then interacts with Strata to finalize ownership transfers. Authorized CSD participants. Examples: Absa Bank Limited, Citibank NA, South Africa, First Rand Bank Limited, Nedbank Limited, Standard Bank of South Africa Limited, and others. Only participants can inspect a company's uncertificated securities register, subject to CSD rules. 8.4 Securities held by nominees. Nominee, a person approved to hold securities on behalf of others, appearing as the registered holder while the actual owner is the beneficial owner. The nominee lacks authority to dispose of securities unless explicitly authorized. If a nominee sells securities without authority, the beneficial owner can vindicate, claim back, the securities from a bona fide purchaser. Legal recognition of nominees. Companies Act 2008, S56(1), permits securities to be held by nominees for the beneficial interest of another person. Concerns with nominee-held securities. Insider trading becomes harder to detect. Minority shareholders struggle to identify controlling shareholders. Directors may not receive warning of hostile takeovers. Competition laws are harder to enforce. Companies only communicate with registered shareholders, nominees, not beneficial owners. Disclosure requirements. S56(3). 4 nominees must disclose the identity of beneficial owners and their holdings monthly. S56(9). Beneficial owners may vote only if their name appears in the company's register of disclosures, or they hold a proxy from the registered holder. S56(2). Extends beneficial interest to holding companies of subsidiaries holding securities. This provision is problematic due to the logical impossibility of 2 entities simultaneously holding beneficial interest unless held jointly. A company suspecting its securities are held by a nominee may require verification of beneficial ownership. 8.5 Transfer of shares. A share is movable property, transferable as per the Companies Act 2008. Private companies must restrict share transferability, often via a right of preemption. Existing shareholders get first option to buy. Board consent for share transfers. Case study: Visa Citrus Proprietary Limited v. Huda Hoop Citrus Proprietary Limited and others. Company G's MOI required board approval for share transfers and stated directors could refuse without giving reasons. VC challenged this, seeking an amendment to force directors to provide reasons. Court held. Restriction clauses of this nature are common and valid. Boards must act in good faith in the best interests of the company, but this does not require giving reasons. Giving reasons could harm business strategy and third-party relations. If the board acts improperly, the remedy lies in challenging the decision, not amending the MOI. 8.5.1 Registered transfer of certificated securities. Of the sale of certificated securities, transfer occurs through cession, followed by registration. The company may not register a transfer unless a valid transfer instrument is provided. Once registered, the company must update its securities register with the new owner's details. Issue a new certificate to the transferee. 8.5.2 Transfer of uncertificated securities and liability. Applies only to uncertificated securities recorded in an electronic register. Ownership transfer occurs through debiting and crediting accounts in the register, ensuring simultaneous ownership and registered transfer. Ownership remains valid despite fraud, illegality, or insolvency, unless the transferee was aware of these issues. The common law right to vindicate stolen uncertificated securities is removed. Liability and indemnification. Perpetrators of unlawful transactions are liable for direct losses. Persons instructing transfers must warrant legality and indemnify the company, CSD, and participants. CSD or participants making unauthorized transfers must indemnify the company and affected parties. Next page, Chapter 9, Public Offerings of Securities. 9.1 Introduction to Public Offerings. Companies need cash for operations, expansion, or special projects. One method of raising funds is offering shares or securities to the public. There is potential for abuse, necessitating full disclosure to protect investors. A prospectus is required for public offerings, detailing company affairs for informed decision-making. The Companies and Intellectual Property Commission, CIPC, registers a prospectus but does not endorse the investment. Public offerings provide entrepreneurial opportunities while requiring transparency. Chapter 4 of the Companies Act, 2008, SS 95-111 modernizes and simplifies regulations on public offerings. Private companies cannot offer securities to the public, SA 2B, 2AA, while public companies can. The law balances transparency and overregulation to ensure investor protection without stifling entrepreneurship. 9.2 General restrictions on offers to the public. No initial public offering, IPO, unless accompanied by a registered prospectus. Primary offering, a company raises funds by issuing new securities, requires a prospectus if unlisted. Secondary offering, shareholders sell their existing shares, listed shares, no prospectus required, regulated by the stock exchange. Unlisted shares, requires a registered prospectus or written statement, S101. If a listed company offers more shares, compliance with exchange rules is sufficient, no prospectus needed. If an unlisted company offers securities to the public, a prospectus is mandatory. 9.3 Important definitions. 9.3.1 Primary offering, an offer to the public by a company for the issuance of new securities to acquire funds. 9.3.2 Secondary offering, a sale of existing securities by a shareholder, not the company. 9.3.3 Initial public offering, IPO, the first public offering of securities by a company. Distinguished from a primary offering, as further primary offerings may follow. 9.3.4 Application of the Companies Act, 2008 offer to the public includes offers to any selected section of the public. Secondary offers of listed securities via an exchange are excluded from the definition. Goldfields Limited v. Harmony Gold Mining Company Limited, Harmony's offer to acquire Goldfields shares was contested as a public offer. The court ruled it was not, as it targeted a specific class of property owners. The Companies Act, 2008 now includes such offers in the public offer definition to overrule this decision. Rights offers, offers made to existing shareholders. Renounceable, shareholders can transfer rights to another person. Non-renounceable, only the existing shareholder can accept the offer. Next page. 9.4 Actions that are not offers to the public. Section 96 of the Companies Act outlines 7 exceptions to the definition of an offer to the public under Section 95, exempting such offers from prospectus requirements. 1. Specified share dealers and institutional investors, offers made only to stockbrokers, authorized financial service providers, and financial institutions. 2. Sophisticated investor exception. Investors acting as principals must meet a minimum prescribed acquisition cost, not less than a 100,000. 3. Non-renounceable offer, offers made only to existing security holders or related persons. 4. Rights offer, applies to listed securities. 5. Offers to directors or prescribed officers, provided the offer is not renounceable to third parties. 6. Employee share scheme, requires compliance with Section 97, includes appointment of a compliance officer, and provision of prescribed information. 7. Small issue or seed capital exception, offers made to a maximum of 50 persons, with a total subscription price not exceeding the prescribed amount. 3 exceptions apply only to subscriptions, rights offers, employee share schemes, and small issues. 4 exceptions apply to both subscriptions and sales, institutional investors, sophisticated investors, non-renounceable offers, and offers to directors. Statutory prospectus requirements do not apply to offers meeting these exceptions. 9.5 The prospectus. A registered prospectus is required for initial public offerings, IPOs, primary offerings, secondary offerings, unless accompanied by a written statement. The Act also restricts advertisements related to public offers unless a registered prospectus is issued. 9.5.1 Definition of prospectus. The Companies Act, 2008, does not define prospectus but defines a registered prospectus under Section 95(1) as one that complies with the Act, has been filed with the Commission, or approved by an exchange for listed securities. A prospectus is valid only if registered and remains current. 9.5.2 Form, content, and supporting documentation. Regulations prescribe the form and content of a prospectus. It must include all information necessary for an investor to assess company's financial health, assets, liabilities, financial position, profits or losses, and cash flow. Details of the securities being offered. Attachments. Any material agreement required by regulations must be included. The Commission or exchange may allow omissions if disclosure is burdensome, detrimental, or against public interest, and investors are not unduly prejudiced. A duty to correct errors exists while an IPO, or primary offering of unlisted securities, remains open. Updates must be registered as a supplement, be published to known recipients, and included in future distributions. 9.5.3 Underwriting. Companies often underwrite public offers to guarantee success. An underwriter agrees to purchase unsold securities, ensuring the issue's success. If a prospectus states that the issue is underwritten, the underwriting agreement and an affidavit confirming the underwriter's ability must be filed before registration. 9.5.4 Registration and publication. A prospectus must be registered before issuance. Conditions for registration. It must comply with the Act. It must be filed within 10 business days after its date. The Commission notifies the filer once registered. Issuance is restricted to within 3 months of registration. 9.5.5 Restrictions on advertisements. Advertisement, any public communication via any medium, including electronic formats. If not part of a registered prospectus, advertisements must include a disclaimer stating it is not a prospectus and where a full prospectus can be obtained. Avoid misleading statements about the offer or its material aspects. Advertisements do not need to be filed with the Commission or registered with an exchange. 9.5.6 Compliance Provisions and Allotment Restrictions. Allotment Restrictions. Securities may not be allotted more than 4 months after prospectus filing. Subscription applications must be attached to a prospectus. Minimum subscription must be met before allotment. If not met within 40 business days, funds must be refunded. Premature allotments are voidable at the applicant's option. Cooling off period. No allotment or acceptance may occur until the 3rd day after prospectus issuance. Invalid non-compliance does not affect the allotment's validity. Listing condition. If a prospectus states an application has been made for listing, the application must actually be made. Any allotment is conditional on successful listing. Next page. 9.4 Actions that are not offers to the public. Section 96 lists 7 exceptions where an issue is not considered an offer to the public, thereby exempting the issuer from the onerous prospectus requirements. 1. Specified investors offers made only to share dealers, stockbrokers, financial institutions, and authorized financial service providers. 2. Sophisticated investors acquiring securities worth at least $100,000. 3. Non-renounceable offers made only to existing security holders or related persons. 4. Rights offers concerning listed securities. 5. Directors and officers offers made exclusively to company directors or prescribed officers and their related persons, unless renounceable. 6. Employee share schemes offers under S97 to employees, with compliance obligations including appointing a compliance officer. 7. Small issue seed capital exemption offers accepted by a maximum of 50 persons, where the total subscription price does not exceed the prescribed amount. The last 3 exceptions apply only to securities for subscription, while the others apply to both subscription and sale. If an offer falls within these exceptions, the statutory requirements for public offerings do not apply. 9.5 The Prospectus. 9.5.1 Definition of a prospectus. The Companies Act 2008 does not define prospectus but defines a registered prospectus in S95(1) as one that complies with the Act, has been filed with the Commission or, for listed securities, approved by the relevant exchange. A document is considered a prospectus only if it meets prescribed form and content requirements and is registered by the Commission. 9.5.2 Form, content, and supporting documentation. A prospectus must provide all necessary information for an investor to assess company's financials, assets, liabilities, financial position, profits, losses, and cash flow, securities offered, nature, rights attached, and investment potential. Material agreements must be attached. The Commission or exchange may allow omissions if disclosure is burdensome, detrimental to the company, against public interest, provided that investors are not prejudiced. If an initial public offering, IPO, or primary offering remains open, responsible persons must correct errors, report material changes, register and publish supplements to the prospectus. 9.5.3 Underwriting. Companies typically arrange for an underwriter to guarantee the success of the public offering. If an underwriting agreement exists, the prospectus must include a statement confirming underwriting, the underwriting agreement, an affidavit proving the underwriter's ability to meet obligations. 9.5.4 Registration and publication. A prospectus must be registered before issuance. It must be filed within 10 business days of its date and issued within 3 months of registration. The public must have access to the prospectus before acquiring shares. 9.5.5 Restrictions on advertisements. Advertisements related to securities offerings must either be a registered prospectus or comply with S98(2) by including a disclaimer that it is not a prospectus and specifying where to obtain the full document. Advertisements must not contain false, or misleading information. 9.5.6 Compliance and restrictions on allotment. Securities allotments must occur within 4 months of filing the prospectus. Minimum subscription must be met, otherwise, funds must be refunded within 40 business days. Allotments made before the minimum subscription is met are voidable. Allotment cannot occur before the 3rd day after issuing the prospectus, ensuring investors have time to evaluate it. A prospectus stating that securities will be listed must have an actual listing application filed. 9.6 Liability for untrue statements in a prospectus. Chapter 4 of the Act imposes liability for misleading statements in a prospectus. This is in addition to remedies under common law, delictual liability for fraud or negligence. Other provisions of the Act. S-104(1) grants investors a right to compensation for losses without proving fault. Liable persons include directors, promoters, and issuers of the prospectus, persons authorizing the offer. Liability extends to enforcement measures in Chapter 7, S-106(1), and compliance actions under S-171. Untrue statements include misleading statements in context, material omissions intended to mislead. Experts making untrue statements are also liable. S-104(3) provides statutory defenses, such as reliance on an expert opinion. 9.7 Regulation of secondary offerings. S-101 governs secondary offerings, defined as the sale of issued securities to the public by an existing holder, not the company. Secondary offerings do not require a prospectus if they fall under one of the 4 exceptions. 1. Offers not to the public. 2. Offers of listed securities. 3. Offers by an executor or trustee of an estate. 4. Offers made via auction or sale in execution. If no exception applies, the seller must provide either the original registered prospectus, or a written statement containing offeror's details, company financials, security details, dividends, issue price, acquisition price, reasons for any price discrepancies. Failure to comply with S-101 may result in criminal liability for publishing an untrue statement, civil liability. Directors knowingly approving a false statement must compensate the company. Regulatory action. The company's commission may issue compliance notices to remedy non-compliance. Next page. 9.6 Liability for untrue statements in a prospectus. Chapter 4 of the Act regulates liability for untrue statements in a prospectus to prevent misleading investors. Liability under Chapter 4 is in addition to other remedies available under the Act or common law. Common law. A subscriber or purchaser must prove all elements of delictual liability, including fault, for fraudulent or negligent misrepresentation. Statutory liability, S-104(1). A person who acquires securities based on a prospectus can claim loss or damages from untrue statements without proving fault. Liable persons include directors, promoters, persons who authorized the prospectus, or made the public offer. These persons may also be held liable under Chapter 7, S-106(1), enforcement provisions, and could be subject to a compliance notice, S-171. Disputes on liability may be referred to the company's tribunal, S-166. Untrue statement. Any misleading statement or omission in the context it is made, S-104(3), includes statements made by an expert. If misleading. Defenses, S-104(3). Reliance on an expert's reasonable competence. 9.7 Regulation of secondary offerings. Secondary offering, S-101. Sale of issued securities by a person other than the company or subsidiary. Seller benefits personally, not the company issuing securities. Key regulatory differences. The Companies Act, 2008 follows similar criteria as primary offerings in determining when a secondary offering qualifies as an offer to the public. Offers falling under the 4 exceptions do not require a prospectus. Exemptions apply to Listed securities, S101 does not apply. Offers by executors of deceased estates, trustees of insolvent estates, sales in execution, or public auctions. Practical application. Mostly applies to offers of unlisted shares in public or private companies. To avoid S101 compliance, sellers can make a non-renounceable offer to other shareholders. Request the company to acquire the shares under S48. Requirements: if no exemption applies, offer must be accompanied by either 1. The registered prospectus from the primary offering, or 2. A written statement, signed, dated, with required particulars, S116, including offerer and company details, issued securities and dividend payments, issue price versus acquisition price, explanation for any difference, last annual financial statements of the company, consequences of non-compliance, no statutory remedies for prejudiced parties, criminal liability, S116. Anyone involved in preparing or approving a misleading statement is guilty of an offense. Directors knowingly signing a false statement are liable to compensate the company. Potential remedy: application to the company's commission for a compliance notice. Chapter 10: Important transactions requiring additional regulation. 10.1 Important transactions. Fundamental transactions significantly affect the company's ownership or assets and require additional regulation. Types of fundamental transactions. 1. Disposal of a majority of assets or undertaking. 2. Amalgamation or mergers. 3. Schemes of arrangement. Applies to all companies, public and private. If a fundamental transaction is also an affected transaction, the Takeover Regulation Panel has jurisdiction. Chapter 5. A company is regulated if it is a public company or state-owned enterprise, unless exempted under S9. A private company if 10% plus of issued securities transferred in the past 24 months. ITSMA states that it is subject to Chapter 5 and takeover regulations. 10.2 Identifying fundamental transactions. Introduced by Companies Act, 2008, includes disposal of major assets or undertaking, S112, amalgamations or mergers, S113, schemes of arrangement, S114. 10. 2. Disposal of all or a greater part of assets or undertaking. Definition: sale of more than 50% of a company's gross assets at fair market value or more than 50% of the company's entire undertaking. Regulated by S112, requiring compliance with S115, shareholder approval process. Exceptions: S112(1). Part of a business rescue plan. Transfers within the same group of companies. Shareholder protection, S115. Disposal requires approval by special resolution of shareholders. Procedural safeguards apply. 10.3 Regulation of fundamental transactions. 10.1 Regulation of substantial disposals. Subject to S112 and S115 requirements. Shareholder approval required, special resolution. 10.3.2 Regulation of mergers or amalgamations. 10.3.2 On the amalgamation or merger agreement. Must be approved by the board and shareholders of each merging company. 10.3.2 The shareholder approval process. Special resolution required by each merging company's shareholders. 10.3.2 The re-implementation of the amalgamation or merger. Must follow statutory processes to ensure compliance with merger laws. 10.3.3 Regulation of schemes of arrangement. Governed by S114 and S115. Requires court approval if dissenting shareholders challenge the scheme. 10.3.4 Opposition to fundamental transactions. Dissenting shareholders. Shareholders opposed to a fundamental transaction can exercise appraisal rights, S164. 10.4 Appraisal remedy. Allows dissenting shareholders to demand fair value for their shares if they vote against a fundamental transaction. 10.5 Affected transactions and the role of the Takeover Regulation Panel. Two types of affected transactions. 1. Fundamental transactions involving regulated companies. 2. Acquisition of prescribed percentages in voting securities. Key affected transactions, S117 1C. Disposal of major assets by a regulated company. Mergers involving at least one regulated company. Schemes of arrangement between a regulated company and shareholders. Acquisition of 5%, 10%, or 15% plus voting securities. Mandatory offers and squeeze-outs. 10.5.1 Mandatory offers. If a person acquires more than 35% of a regulated company's voting securities, they must offer to purchase remaining shares at a fair price. 10.5 To compulsory acquisitions and squeeze-out transactions. If a shareholder reaches 90% ownership, they can force minority shareholders to sell under fair terms. 10.6 Impact of the Companies Act, 2008 on corporate restructuring in South Africa. Introduced comprehensive regulation for fundamental transactions. Strengthened shareholder protection mechanisms. Expanded takeover regulation panel's role. Ensured procedural safeguards for major corporate restructuring activities. Next page. Chapter 10 Important transactions requiring additional regulation. 10.1 Important transactions requiring additional regulation. Transactions significantly affecting company ownership or shareholding attract additional regulation under the Companies Act, 2008. Fundamental transactions. Disposals of the majority of a company's assets or undertaking. Mergers, amalgamations. Schemes of arrangement. Affected transactions. Fundamental transactions involving regulated companies. Transactions triggering the jurisdiction of the Takeover Regulation Panel, TRP, under Chapter 5 of the Companies Act, 2008. Regulated companies, as per the Act. Public companies. State-owned enterprises, unless exempted under S9. Private companies if more than 10% of issued securities have been transferred in the preceding 24 months. The Memorandum of Incorporation, MOI, subjects the company to takeover regulations. S117 1C Companies Act, 2008, defines affected transactions including disposal of all or greater part of assets or undertaking of a regulated company, mergers involving at least one regulated company, schemes of arrangement between a regulated company and its shareholders, acquisitions leading to control over 5%, 10%, or 15% of voting securities, mandatory offers and compulsory acquisitions. 10.2 Identifying fundamental transactions. Introduced in the Companies Act, 2008 to cover disposals of all or greater part of assets or undertaking, amalgamations or mergers, schemes of arrangement. 10.2.1 Disposal of all or greater part of assets or undertaking. Definition: sale of more than 50% of a company's assets or undertaking at fair market value, governed by S112 of the Companies Act, 2008, read with S115, exceptions under S112(1). Transactions under a business rescue plan, intra-group transfers, for example, between wholly owned subsidiaries or parent companies. Requirements for disposal. 1. Special resolution of shareholders required. 2. Compliance with procedural requirements. 10.2. Amalgamation or merger. Definition: combination of assets and liabilities of two or more companies into one or more surviving or newly formed entities. Types of amalgamations or mergers. 1. Formation of a new company, all original companies cease to exist. 2. Survival of one or more merging companies, others dissolve. Key features: governed by the Companies Act, 2008 as a fundamental transaction, No requirement for court approval, except in limited circumstances. Shareholders may seek remedies under S-164, appraisal rights, and S-163, relief from unfair conduct. _ 10.2.3 Schemes of arrangement. Definition: an agreement between a company and its security holders, often used for takeovers, restructuring, or share capital reorganization. Types of share capital reorganizations: consolidation of different classes of securities, division of securities into different classes, expropriation of securities from holders, exchange of securities, reacquisition of securities by the company. Combination of the above methods. Key advantages: flexible mechanism for takeovers and mergers, no explicit solvency and liquidity test requirement, can be used to circumvent traditional approval processes. Next. Page 10.2. Amalgamation or merger. Definition: combining assets and liabilities of two or more companies into one or more surviving or new entities. Results: some or all merging companies cease to exist. Surviving or new companies inherit all assets and liabilities. Types: 1. Formation of new company. All merging companies dissolve, and assets or liabilities transfer to new companies. 2. Survival of at least one merging company. Non-surviving companies dissolve, and assets or liabilities transfer to surviving or new companies. Legal context: not separately defined in the Companies Act 2008. Mergers are straightforward and flexible under the Act. Limited court involvement, faster and less costly than schemes of arrangement. Shareholder protection. Appraisal rights, S-164, protection for dissenting shareholders. Unfair prejudice remedy, S-163, relief for unfair conduct. _ 10.2.3 Schemes of arrangement. Definition: agreement between company and its securities holders for restructuring share capital. Methods: consolidation or division of securities, expropriation or exchange of securities, reacquisition of securities by the company. Usage: common for takeovers. Example: India Company Limited restructures share capital by converting convertible preference shares into ordinary shares, expropriating a portion of preference shares. Result: share capital simplified, eliminating preference shares. Commercial benefits: simplifies share capital administration, grants voting rights to shareholders, provides flexibility in takeovers compared to traditional acquisitions. _ 10.3 Regulation of fundamental transactions. Governed by Part A, Chapter 5 of the Companies Act, 2008. 10.1 Regulation of substantial disposals. Key requirements: special resolution by shareholders, not ordinary resolution. Narrow scope of approval, S-112(5), no broad pre-authorization for multiple disposals. Fair market value requirement, S-112(4), asset price must reflect true market value. Voting rights restriction, S-115(4), acquiring parties excluded from voting. Takeover provisions apply if disposal involves a regulated company. Holding company approval, S-115(2)(b), if disposal substantially affects holding company's assets. 10.3.2 Regulation of mergers or amalgamations. Key stages: 1. Merger agreement, written contract specifying transaction details. 2. Shareholder approval process, compliance with quorum and resolution requirements. 3. Implementation of merger. 10.2. 1. The amalgamation or merger agreement, S-113(2), required details. Moi of new company. Directors of merged entity. Share conversion mechanism. Consideration for non-surviving shareholders. Asset and liability allocation. Implementation strategy and management plans. Estimated transaction cost. 10.3. 2 Structures under the Companies Act, 2008. Flexible structuring options. Reverse triangular merger. Buyer, B, creates a merger subsidiary, S. S merges into target, T, with T surviving. T's shareholders receive shares in B. Common in US and Japan for liability shielding. Top hat or double dummy merger. New holding company, NewCo, creates two merger subsidiaries. Each subsidiary merges with a different pre-existing company. Both companies survive as wholly owned subsidiaries of NewCo. Used in high-profile mergers, for example, Time Warner, ConocoPhillips. Reverse merger. Smaller company acquires larger company to avoid contractual obstacles. Example, Merck and Schering-Plough merger. 10.3.2.3 The shareholder approval process. Board submit the merger agreement to shareholders. Solvency and liquidity test. Boards must ensure merged entity meets financial requirements. Notice requirements. Shareholders must receive a summary of the merger agreement. Must inform shareholders of their rights under S115, shareholder approval and court recourse. S164, appraisal rights for dissenting shareholders. Voting thresholds. Quorum, 25% of voting rights. Approval special resolution, typically 75% of shareholders present. Possible reduction, under S65, the threshold may be reduced to 60% plus one vote. Next page. Regulation of Fundamental Transactions. Companies Act, 2008, Chapter 5, Part 10.3 Regulation of Substantial Disposals. Approval requirement. Disposal of the greater part of a company's assets or undertaking requires a special resolution of shareholders, not an ordinary resolution. Protects minority shareholders by enabling them to block large disposals. Restrictions on broad resolutions, S112(5). Prevents companies from obtaining broad, general approval for multiple disposals. Each disposal requires specific authorization or ratification. Fair market value requirement, S112(4). Assets must be disposed of at fair market value, aligned with financial reporting standards at the time. Conflict of interest protection, S115(4). Voting rights of acquiring parties, or related parties, excluded from the quorum or vote. Prevents acquirers from voting in their favor to approve the disposal. Takeover provisions. If the disposal involves a regulated company, it may be subject to takeover provisions unless part of a business rescue plan. Holding company approval. S115(2)(b). If the disposal substantially affects the holding company's assets or undertaking, approval from the holding company's shareholders is also required. 10.3.2 Regulation of mergers or amalgamations. Key stages of a merger or amalgamation. 1. Merger agreement. 2. Shareholder approval process. 3. Implementation of the merger. 10.3.2.1 The amalgamation or merger agreement, S113(2), written agreement required, detailing moi of the new merged entity, proposed directors of the merged company, share conversion terms and method, non-share consideration details if applicable, asset and liability allocation between merged entities, management strategy post-merger, estimated transaction cost, flexible structures under the Act. Reverse triangular merger, most common in the US and approved for cross-border mergers in Japan. Top hat or double dummy structure, used for mergers of equals, for example, Time Warner. Reverse merger, for example, Merck and Schering-Plough, smaller entity technically acquires the larger one. 10.3.2 Shareholder approval process. Board submit the merger proposal for shareholder approval. Requirements. Notice of shareholders meeting must include copy or summary of the merger agreement, shareholder rights under S115 and S164, quorum, at least 25% of voting rights exercised, special resolution. typically requires 75% of shareholders present to approve, may be reduced to 60% plus one vote, S65. Underscore. 10.3.2.3 Implementation of the amalgamation or merger. Creditor notification and court review. Creditors must be notified before implementation. If a creditor believes they will suffer material prejudice, they may apply to court within 15 business days. Court must ensure creditor acts in good faith. They will be materially prejudiced. No alternative remedies exist. Filing with the Companies Commission. Notice of merger must confirm compliance and include any new WAS, required regulatory approvals, for example, competition approval. Commission issues a registration certificate for the new company and deregisters any merging companies that will not survive. Effects of the merger. All assets and liabilities automatically transfer to the merged entity. Shares held by merging companies in each other are cancelled, no repayment or conversion. Existing liabilities and pending legal proceedings remain enforceable against the new merged entity. S116(6)b. Publicly registered assets are automatically re-registered under the new entity. S116(8). Underscore. 10.3.3 Regulation of Schemes of Arrangement, S114, S115, and S164. A company may propose a scheme of arrangement with security holders, not in liquidation or business rescue. The scheme may involve share-for-share exchanges, share repurchases, independent expert report required. Must be impartial and detail. Affected shareholder categories, material effects and adverse consequences, special resolution required. 25% quorum required at shareholders' meeting. 75% approval needed. Takeover provisions apply. If involving a regulated company, the scheme is subject to takeover regulations unless part of a business rescue plan. Underscore. 10.3.4 Opposition to fundamental transactions. Dissenting shareholders, S115. Shareholders may challenge a fundamental transaction in court if greater than or equal to 15% of voting rights were opposed. Any dissenting shareholder may require the company to seek court approval before implementing the transaction, if less than 15% of voting rights opposed. A shareholder may apply to court for leave to challenge the transaction. Court may grant leave only if the shareholder acts in good faith, has a prima facie case, can sustain proceedings. Court may set aside resolution if the resolution is manifestly unfair to any class of shareholder, the vote was tainted by conflict of interest, non-disclosure, or procedural irregularity. S115 Rights Supplement. S164 Appraisal Rights. Underscore. 10.4 Appraisal Remedy, S164, inspired by U.S. corporate law, allows dissenting shareholders to sell their shares to the company at fair value if they oppose a fundamental transaction. Applies to mergers, schemes of arrangement, disposals of major assets, and WA amendments affecting shareholder rights. Process. 1. Written objection before shareholders' meeting. 2. Vote against the resolution. 3. If the resolution is passed, company must notify dissenting shareholders. They have 20 days to demand fair value for their shares. 4. Company must offer fair value. If accepted, shares are acquired by the company. 5. If no offer is made or is disputed, court determines fair value, valuation at time of resolution. 6. Court's order. Shareholders must either withdraw their demand or tender shares to the company for court-determined fair value. Case law. Lois v. Jandak, court affirmed that it can summon parties or documents for fair value determination, even though the Act does not explicitly state this. Significance of appraisal rights. Protects minority shareholders. Ensures fair exit value in fundamental transactions. Underscore. These regulations establish clear protections for shareholders while allowing companies, to structure flexible transactions within legal safeguards. Next. Page 10.5 Affected transactions and the role of the Takeover Regulation Panel. Affected transactions fall under the jurisdiction of the Takeover Regulation Panel if they involve a regulated company. The Takeover Regulation Panel is established under S-100 and 96(1) of the Companies Act, 2008 to regulate affected transactions in accordance with Chapter 5 of the Companies Act, 2008 and the Takeover Regulations. The Takeover Regulations, issued by the Minister of Trade and Industry after consulting the panel, have statutory backing but remain flexible, unlike strict statutory enactments. Under the Companies Act, 1973, the predecessor Securities Regulation Panel issued the Takeover Rules, which did not have legislative status. The Companies Act, 2008 upgraded these rules to secondary legislation as Takeover Regulations. Significance of the Takeover Regulation Panel. The panel regulates high-value transactions. 2008, 58 affected transactions worth approximately of $55 billion. 2007, 64 transactions worth over $80 billion. Not all mergers and acquisitions fall under the panel's jurisdiction, only transactions involving regulated companies. The panel's purpose: ensure market integrity and fairness to securities holders. Ensure necessary information is provided for informed decision-making. Allow time for companies and shareholders to seek advice regarding offers. Prevent actions that frustrate or impede offers or fair decision-making. Powers of the Takeover Regulation Panel. Require filings for approval of documents related to affected transactions. Issue clearance notices for compliant offers and transactions. Conduct investigations and issue compliance notices under Chapter 7 and the Takeover Regulations. Enforce compliance by issuing orders to prohibit or require specific actions. Divest acquired assets or account for profits. 10.5.1 Mandatory offers. Definition: occurs when one or more related persons or entities acquire at least 35% of a company's voting securities. The acquirer is then legally required to offer to purchase the remaining securities. Purpose: ensures equal treatment of all shareholders. Prevents control being acquired via selective offers to majority shareholders at a premium while minority shareholders are ignored. Triggers for a mandatory offer: a regulated company repurchases its own voting securities. A person or concerted group acquires a beneficial interest in securities crossing the 35% threshold. Process: within 1 day of completing the mandatory offer, notice must be given to remaining shareholders. Within 1 month, the offerer must deliver a formal written offer in compliance with the Takeover Regulations. 10.5 To compulsory acquisitions and squeeze-out transactions. Definition: occurs when an offerer acquires 90% of a class of securities in a company. The offerer can then force remaining shareholders to sell under the same terms. Process: if an offer is accepted by holders of at least 90% of a class of securities within 4 months, the offerer must notify remaining shareholders, express intent to acquire their securities. Remaining shareholders have 30 business days to seek a court order preventing the acquisition, or altering the terms of the acquisition. 10.6 Impact of the Companies Act, 2008 on corporate restructuring in South Africa. Bring South Africa's corporate restructuring laws in line with developed economies. Introduces a standalone amalgamation or merger provision in S-100 and 13 encouraging business combinations beyond court-driven schemes of arrangement. Emphasizes the market for corporate control. Encourages takeovers and mergers by recognizing that underperforming companies may be targeted for change. Creates an environment where corporate directors must remain competitive to avoid losing control. Chapter 5, Fundamental Transactions, Takeovers and Offers, provides various mechanisms to facilitate changes in corporate control. The market for corporate control. Example: Liberty Holdings Limited, 2010, underperformed relative to peers. Reported 91% earnings drop, while competitors' stock prices rose significantly. Such underperformance exposes a company to potential takeovers, as new management may optimize its resources.